started. I'm Krista Ney, one of your hosts today from Episcopal Communities and Services. We have a great program today. I'm going to just share with you a little bit about your hosts for today. Episcopal Communities and Services is a retirement community management organization. We have 4 communities in Southern California. 3 are in LA County. We've got the MonteCedro in Altadena, the Canterbury in Ranchos Palos Verdes, and 12 Oaks in Glendale. We also have a community in Orange County, the Covington in Aliso, Viejo. I am actually, behind me is one of our apartments at one of the communities. We have very well appointed apartments and are open for tours if anybody's interested in coming to see us and who we are and what we do. We will put information up at the end of the session to share with you our contact information. We'd love to see you. Our residents and staff are fully vaccinated, so if there's any concern there, we have mandated that it is for our staff that we are vaccinated, and so we're open to have you come visit with us. Today is a webinar, so your cameras and microphones have been turned off. We are also broadcasting live on Facebook. So your information as a registrant is protected. There's no sharing of that information, just to reassure you. We will be taking questions, and we've left plenty of time. I know that there's a lot of questions out there that you all have. So if you are on Facebook, you can add your questions in the comment section. If you are live with us on this Zoom video conference, to submit a question, you take your cursor, or if you're on an iPad, scroll down to the bottom of your screen, and you can see a menu bar come up, and you will see a little icon that says chat. If you click that icon, there should be a window that comes up, and there's a 2, and it's an all panelists or just to the to everybody, all panelists and registrants. If you click the arrow down and select all panelists and attendees, that would be helpful so that we're not repeating our questions if you're reviewing those. You will probably have a lot of your questions answered within the first 15 minutes of this presentation, so you might want to hold off for that. But if not, just go ahead and feel free to enter your questions, and Jeff will address those as they come in at the end of his presentation. So with that said, again, welcome. If you just joined us, this is a session on Proposition 19. That is a state proposition. So it's to be determined how all the counties are implementing that, but we'll get to that later. I will go ahead and introduce Jeff, our presenter for today. Jeff Prang is the Los Angeles County Assessor. He was elected in 2014 as the 27th assessor for the County of Los Angeles and re-elected in 2018. Raised in Warren, Michigan, Assessor Prang is a graduate of Michigan State University. And after graduation, Mr. Prang relocated to California, where he served nearly 18 years as a council member for the city of West Hollywood, including 4 terms as mayor, among many other positions in the public sector. Upon taking office in 2014 as the Los Angeles County Assessor, Mr. Prang implemented sweeping reforms to ensure that the strictest ethical guidelines rooted in fairness, accuracy, and integrity would be adhered to in his office. Assessor Prang is State Board of Equalization licensed appraiser and administers the largest office of its kind in the nation, with 1,300 employees that provide the foundation for a property tax system that generates over $17 billion annually. And we just learned that Jeff adopted a 9-month-old Pomeranian puppy over Christmas. And there is a place called Pomerania, which his grandfather is from. So we learned that about him. And with that, Jeff, it's all yours.
Thank you so much, Krista. I appreciate that kind introduction. I'm really thrilled to have the opportunity to be here to share some information about my office with all of your viewers. I know what everybody's probably thinking, that how do trying to find different programming to present to such a diverse group. Where do you find something that is really exciting, captivating, and absolutely riveting? Well, you go to the county property tax assessor. And I'm thrilled to be able to play that role for you today. So I'm hoping that we'll have good information for you that will be useful, and look forward to your questions. I do have a number of my staff members on the line. Aldo Ariano Macias is going to be working the PowerPoint, and Robert Izozaki is a specialist expert. So if you ask me questions that are too hard, Robert's going to help me get down into the weeds to answer them. So let me begin by telling you not only what the assessor's office does, but just importantly, what we do not do. The one thing that everybody thinks I do that I actually don't do is I do not collect taxes. There's another guy who does that, and he has a very intuitive title. He's called the tax collector. I am called all the time. People refer to me as the tax assessor. I can assure you there is no such thing in the state of California as a tax assessor, which is actually the conflation of two separate offices, the assessor and the treasurer tax collector. For those who don't know much about the assessor, I am one of 3 countywide elected officials. The other 2 being much better known than me, that's the sheriff and the district attorney. And as Krista stated, I administer a department with 1,300 employees. We're located in 6 different offices throughout the county. We are the largest local property assessment agency in the United States. I am responsible for establishing the value for over 2.5 million real property parcels and business assessments each year, which this year was valued at nearly $1.76 trillion. And that's just the assessed value. The market value is very much higher. This year, property tax revenues that begin with my office's valuation will provide over $17 billion in revenue for vital public services that we all rely upon, such as public health, hospitals, parks, libraries, police, and roads. Local government is funded predominantly through property taxes and sales taxes, and the property tax system begins with my office. But in addition to real property, which includes, as you know, land and improvements, I'm also responsible for assessing the value of what's known as business personal property, which includes office furniture, equipment, and machinery. It also includes aircraft, both commercial as well as general aviation aircraft, mobile homes, boats, and believe it or not, even racehorses. So the primary responsibility of the assessor is the production of the annual assessment roll, which is kind of a fancy way of referring to the inventory of all taxable property in the county. The assessment roll is the foundation for the property tax system. My office determines the value of each taxable property in the county. The auditor controller determines how much you owe. The treasurer tax collector sends out the bills and collects the payments. And those are the different departments that each have a role in property tax administration. I can report to you that just a couple of weeks, just 1 month ago, we finished our annual work, which is the production of the assessment roll. We work on a fiscal year, July 1st to June 30th. And I can report that property values in the county continue to grow despite the recession caused by COVID. Although the growth is not nearly as high as the previous year, it does represent the 11th consecutive year of property value growth countywide since the 2008 to 2010 recession. For this year, the assessment roll grew by $62.9 billion. That's a 3.7% increase over the previous year. While it's not as large as a growth percentage as last year, which was over 6%, when you think about it, given how bad the economy was in the last year, the fact that we still had positive property value growth is quite exceptional. As I stated, the total assessed value of all taxable property is about $1.7 trillion, and that will generate $17 billion in property taxes, which are allocated to schools, municipalities, special districts, and the county. So that's a bit of an introduction to the department and what we do and kind of what's happening at the moment in the market. Let me change subjects to talk about something I know everybody's interested in, and that is Proposition 19. Prop 19 was a ballot measure that appeared on last November's election ballot. It was sponsored by the California Association of Realtors. It is an amendment to Proposition 13 that does two primary things. The first thing it does, and the part that was most popular with the voters, is the element that allows a homeowner who is over 55 years of age, disabled, or the victim of a natural disaster to transfer their property tax base with them when they sell their home and purchase a new one. This component also expands on the previous benefits that were allowed under the previous law. It now allows those qualified homeowners to buy a home anywhere in the state of any value and to transfer their property tax base up to 3 times. The previous law only allowed you to transfer it once. It had to be in one of about a dozen participating counties, and it had to be a home of equal or lesser value to the home that you were selling. The second component about Prop 19, and this one is causing a great deal more concern, relates to the transfer of property between family members, specifically between parents and children, and in some cases between grandparents and grandchildren. We call those intergenerational transfers. This part of Prop 19 was not very well publicized during the campaign, if at all. This component of the law applies to everyone, so there are now some severe restrictions on the transfer of property between family members. Previously, under California law, you could transfer your home of any value and up to $1 million in additional property to your children without that property being reassessed. They could inherit both your property and your tax base. However, under Prop 19, there's new limitations. One limitation is that the only property that your children can inherit along with the tax base is your primary residence. No other property now qualifies. That additional property will now be reassessed upon a transfer to market value. Secondly, in order for your child, or in some cases your grandchild, to qualify to inherit that property and the tax base, they must make that home their primary residence within 1 year of the transfer and file the homeowner's exemption. There's also a limit on how much value of the primary residence and the tax base your children can inherit. To oversimplify, essentially, if the primary residence is worth less than $1 million, your kids or your grandkids can inherit that property without reassessment. But once that property value exceeds $1 million, there's going to be a new and higher tax rate that in effect is a blend of the partial inherited tax base with a partial market rate tax base. And just to restate, under the old law, in addition to inheriting your parents' residence, you could also inherit up to $1 million in additional property without it being reassessed, but that's now been eliminated under Prop 19. One of the most difficult things we're dealing with in my office dealing with Prop 19 is it was written with numerous ambiguities, deficiencies, and inconsistencies. There's a lot of things that are unclear to assessors on how to administer the law. Typically, when a ballot measure is adopted, it is quickly followed by legislation that clarifies those ambiguities. But for some reason or other, when they put this on the ballot, they gave assessors only 3 months to implement this new measure. And had they talked to me, I would have said that we needed at least 18 months because it's a significant change in our operations. The problem that we have right now is that this law is now fully in effect as of April 1st. And there's dozens of questions and problems that me and my colleagues who are assessors in other counties, we simply don't have the answers to. And we don't, as administrators, have the authority to make those interpretations. They have to come from the legislature. Fortunately, while it did take us 6 months of effort to get legislation introduced, we finally have a bill, Senate Bill 539, introduced by Senator Hertzberg, which is working its way through the process. Once it's adopted and signed by the governor, a lot of these incongruities will be addressed. But the problem is right now, there's a lot of things that are not addressed, and people are looking for answers, and we simply don't have them. And let me give you just one example of the challenges in the current language. So let's say you want your children to inherit your property, and you have 4 children. Well, the law says that you can transfer your principal residence, but your children have to move into the property. Under a strict reading of Prop 19, if you had 4 children, for them to get the tax benefit, all 4 would have to move into the property in order to qualify. Obviously, that is an absurd interpretation. Unfortunately, that's what it says. And somebody needs to clarify that. I don't have the authority to clarify that. We need this legislation to say that that's not the case. Another example is, let's say you want to leave your property to your child, but you're forced to move into perhaps into memory care. And the law says that for your child to inherit that property, it has to be their primary residence. But those years that you're living in memory care, it's not your primary residence. Your primary residence is somewhere else. So as the law is written, it would require me to reassess your home to market value, and your children would have to inherit that at a much increased property tax base, because that's what the law says. Now, obviously, these were things that were not the intent. We require that legislation to clarify these points, but these are just some of the illustrations of what was wrong with the way the measure was written. We're trying to fix that so that it doesn't negatively impact any more people than necessary. To try to give as much information as possible to the public, we did create a special site on our webpage that provides a lot of information and tools to help you understand Prop 19. There's a couple of specific tools that will, if you're transferring your tax base to a more expensive home, this tool will tell you approximately what your new tax rate will be. Or if you're giving your property to your children, and they're only qualified for a partial inheritance of the tax base, this will tell them what their new tax rate would be. A couple other miscellaneous things I wanted to touch on. One of the things my department does is we manage a number of programs designed to help people save money on their property taxes. There's programs for seniors, veterans, the disabled. But the most important one I like to emphasize is the homeowner's exemption, which is available to anybody who owns their home and lives there as their primary residence. It'll reduce your assessed value by $7,000 for tax purposes. Granted, it's not a huge savings. It's only $70 a year, but about a third of all LA County homeowners don't apply simply because they don't know about it. And as a result, every year about $30 million in savings go unredeemed. And it's a very simple form. It only needs to be filled out once, and it will apply as long as you own the home. For our heroes who have served in uniform, both the veterans exemption and the disabled veterans exemption are available for additional property tax savings. If you're a single veteran with assets less than $5,000, a married veteran with assets less than $10,000, or an unmarried surviving spouse of an eligible veteran, you can apply for the veteran exemption. And if you're disabled, there's some strict limitations for that. There's a disabled veterans exemption as well. On another issue, I want to talk briefly about trusts. I understand that estate planning requires us to use a number of estate planning devices, one of those being a trust. A revocable trust, there's 2 types of trust, revocable and irrevocable. A revocable trust can be used if a property owner wishes to make provisions for the transfer of the property upon their death, but are not currently ready to make the actual transfer of ownership. For a trust to be revocable, the trustor must reserve the right to terminate the trust and retain all ownership of the property. When the property is placed in a revocable trust, there is no change in ownership, thus no reassessment occurs. But in the event of a revocable trust, upon the death of the trustor, the revocable living trust becomes irrevocable, and that is now a clause for reassessment. An irrevocable trust is a transferable event. It does cause us to reassess the property because an irrevocable trust is just that. It's irrevocable. Once that trust is in place, it is legally constitutes a change in ownership. A couple other notes that are adjacent to that. In those cases, when a property owner dies, there's things that need to take place in order to help with estate planning and inheritance. One of the first things that needs to happen upon the death of a property owner is, under California law, the heirs to an estate have 150 days to notify the assessor that there's been a change of ownership due to the death of the property owner. Failure to file that can oftentimes create complications in inheritance and estate planning. It is required that you file a form which is called change in ownership, death of real property owner. It's a form which is available on my website. It is required even if the property is held in a trust. The fact that the property is a trust does not eliminate the need for you to file that document. Failure to file this document could result in a penalty, although I will say that because close to 100% of the people don't know they're supposed to file that, everybody would end up paying a fine as a result. But failure to do so can create challenges for estate planning. The other thing, if you have children or grandchildren or inheriting property, you also need to file the Proposition 19 form. Keep in mind, you have 12 months to do that. If you don't do it within 12 months, there is no wiggle room, there is no discretion. The property will be reassessed to market. This is different from the previous law, which did provide a great deal of wiggle room, and sometimes you could apply for that transfer of the property to your children or grandchildren, several years late and still get some benefits. That no longer exists under Prop 19. And lastly, I wanted to make you aware of one of my fellow departments, that is the Los Angeles County Department of Consumer Affairs Real Estate Fraud and Information Program. This was organized to protect property owners against real estate fraud. The program is a cooperative effort between my office and the Department of Business and Consumer Affairs. We work closely with residents, prosecutors, police agencies, real estate professionals, and nonprofits to help protect homeowners. The department serves as a central reporting agency for real estate fraud complaints. Our staff are trained and are available to accept complaints of fraud, to mediate disputes when appropriate. There's a lot of folks who send out a lot of information you may get in the mail of trying to get you to pay for services that the county provides for free, or attempt to get information that they that could help them perpetrate further fraud with you. There is a 800 phone number, 800-973-3370, that will get you more information if you think you've been, if you have questions about fraud, or you think you've been the subject of a fraud. So those are the main highlights I wanted to discuss with you today. I want to stop now and answer any questions that you may have. I may have to turn some of the questions over to Robert Izozaki, who is a specialist on some more technical issues, but I'm happy to have this opportunity to share this information with you. I hope it was useful, and I look forward to your questions. And Krista, how would you like me to handle this?
So we can do two things. We've got some questions in the chat. I can either read those to you, or if you want to read them.
A lot of questions, I see.
Yes.
So we'll get through as many as we can. And so let me see. Probably just easiest if I go through them, if that's all right with you. So the first one, and I actually think this came in before I started speaking, and I sent it to Robert Izozaki, but the question says, my brother put his home into an irrevocable trust with me as trustee and his son as beneficiary. The assessor's office reappraised it, saying it was a transfer in ownership, which it was not, although I believe that's not accurate. I appealed, and the reappraisal was reversed. Then after my brother died, I transferred the property to my brother's son. He sold the home. Then they discovered there were supplemental tax bills from the appraisal, which we're told was reversed, but wasn't. We appealed again. We're told the appraiser changed is mined and the taxes were due and delinquent, plus they tell us it's too late to file a claim because the appraisal was 2 years old. So the first thing is our irrevocable trust is a reappraisable event. If that was reversed upon appeal, I'm surprised because I simply don't think that, that's by definition, irrevocable trust is reassessable. But I'm going to ask Robert Izazaki, who's an expert on trusts and ownership issues, to help fill in here.
Sure, and as the assessor read out, it's a pretty specific situation, so we'd be happy to take a look into this in a little bit greater detail. A transfer to an irrevocable trust many times can be a change in ownership event. Again, we'll want to take a look at this specific situation individually, but if you'd like to reach out to our office, we'd be happy to see what's going on here and see if there's anything that needs to be done.
So, Robert, if you could put your email address into the chat. And this question came from John Wingler, and Mr. Wingler, if you could email the property address and the parcel number to Robert's, we'll look into that and see if we can help you out. Obviously, we don't want you to be pay taxes that you don't have to, and we'll do a deep dive just to make sure that everything was done properly. Next question. My wife and I have been living with our in-laws in their home, and we've been supporting them for the last 20 years. When they die, I believe the property will be reassessed and a much larger tax will hit us. Is this true? Yes, it is. So the tax benefit is assigned to the person who owns the property. Your personal living arrangements and financial arrangements are not part of the equation that are considered when it comes to reassessment of property. The property upon their death would be reassessed to market value, which if they've lived there more than 20 years, that will probably be a relatively steep increase in property taxes. There is, that's what Proposition 13 calls for. I'm very sympathetic to the situation. I don't have any authority to do things differently than what Prop 13 requires, which is reassessment upon a change in ownership. Next question. So Krista mentioned that Prop 19 is up to the counties to implement. Actually, that's not accurate. Prop 19 is the law for the entire state of California. It is not an opt-in for counties like the previous propositions 58 and 193. That is correct. So Prop 19 applies to all counties. So the next question says, a part of the bulletin used to promote this event stated that Prop 19 saves taxes. How is that possible? Prop 19 increases property taxes on inherited principal residence properties with a market value of $1 million. So yes, both of those statements are correct. So if you're a senior citizen who is looking to transfer your tax base to a new home, you can do so without reassessment if the property is of equal or lesser value than the one that you're selling. You can transfer your base year to a property that is more expensive. Your taxes will go up, but they won't go up to the full market rate. You will have a blended assessment of the rate that you're transferring, plus that value over $1 million will be assessed at market. So it'll be an increase. It won't be a 100% increase for seniors or the disabled who are transferring their tax base. Secondly, as I stated during my introduction, for inherited property for your children or your grandchildren, there were some significant reductions in property tax benefits. That is also true. Under Prop 19, the only property your children can inherit from you with the tax base is your primary residence. And then essentially, if the property is worth more than $1 million, they too would be assessed at a new blended higher rate. It won't be as high as the full market reassessment value, but it will be higher. So there are some there are benefits for seniors who are moving a lot. there are a reduction in benefits for families. That is, both of those are true. Next question from Jennifer Kennedy. Prop 19's repeal of Prop 58 and 193 was not publicized at all. The marketing was deceptive and intentionally misleading. I think that is not an unfair representation of the campaign. The campaign focused very heavily on the benefits that seniors would get in transferring their base year. There was very little discussion about the transfer of property between families. I was very concerned about that. I'm concerned about that now. I'm not sure that the measure would have been passed by a very narrow margin. I think if a lot of folks knew that they were going to have greatly reduced benefits in transferring their property to their children, it may not have passed. The reason for that, when the California Association of Realtors put the measure together, is that expanding the number of homeowners who could transfer their property tax base without a reassessment was going to create a revenue issues for cities and school districts. Cities rely on the reassessment of property to keep their property tax base growing. But by increasing the number of people who have stabilized property taxes, that was going to have a negative impact on property tax revenue. So the way they compensated for that was by reducing the benefits that were available to families. They did talk a little bit about it in a way that they thought would be well received by members of the public. They referred, you may recall, to the family of the late actor Lloyd Bridges. He had a home in Malibu that had a very, very low assessed value. He was paying about $5,000 a year on his property that was worth millions of dollars. But when Lloyd Bridges died and his children inherited it, they chose not to occupy the home. Instead, they leased it out for almost $20,000 a month, and they maintained this very low tax base. And there was this sense that super rich people shouldn't just be able to create a revenue opportunity off their parents' home. The intent of the previous law was to keep the cherished family home in the family, not to create a tax-free revenue stream. So a lot of people thought that was not unreasonable. However, the way the law was written didn't go after just the 1% who were making money off this loophole. They went after, it included everybody who was inheriting property from their children. And I think I'm troubled by that. And I actually think they need to go back to, the legislature needs to go back to the ballot and try to address that issue. Next question says, our parents own their home in their name. Our parents own their home in the name of their irrevocable trust with children as beneficiaries. Both parents have passed away due to the pandemic. Repairs and the sale of the home has been on hold. The children plan to sell the home in the name of the trust and then split the proceeds. Would it be wiser to transfer the home to the children's names, then sell off? Well, I don't know that I'd want to be in a position to give advice on decisions like that, but let me ask Robert if that, what the impacts of that irrevocable trust are on the children as beneficiaries.
Right. So depending on when the parents or the latter of the parents passed away, the children would be eligible to file for a Prop 58 or a Prop 19 parent-child transfer exclusion. Now, that would apply to the date of death transfer. As to whether or not they eventually transfer it out to themselves and then sell it or sell it directly from the trust, that's going to be something that they'll have to look into a little bit more themselves, perhaps speak with a property tax attorney, agent, CPA, someone who can advise them. Our office, we can provide information, but the question lends itself to a little bit more along the lines of legal advice. So I think Assessor, you're correct that they might want to seek some additional guidance.
Thank you. Next question says, I turned 55 in March of 2022. Can I buy the replacement property now and then sell my primary residence after I turn 55 and still take my current property tax to my new property, even though I purchased it before I was 55 afterward? I don't believe anything can begin until you've met the qualification of being 55 years old. So I would say no. That Robert, do you disagree with that?
That's my understanding as well. I think that is a point that is going to have to be clarified by the legislature. At this point, I believe the BOE's position is that the triggering event for the base year value transfer, the sale of the original property, that's the event that requires the property owner to be 55 or older. They don't speak specifically to the qualification for the purchase of the new property. But again, if you're 55 before either of the two began, that would probably be your safest bet at this point.
Thank you. So next question, what if a person moved into assisted living communities like MonteCedro or Canterbury for medical assistance or ADL? If they rent out their former residence to pay for their care, does an ultimate transfer of children still qualify as a transfer of a primary residence? Again, I think the strict reading of Proposition 19 would say that that would be a transfer, because if you are in assisted living, your home is no longer your primary residence. And the law says that the only property that your children can inherit with the tax base is your primary residence. Your home is no longer your primary, it's now your former residence. So at the time when the property is transferred to your children, it would, under our interpretation of Prop 19, absent legislative clarification, is that that would be a change in ownership and result in a reassessment. And Robert, if you think I'm going off topic, feel free to interrupt me and tell me I don't know what I'm talking about. Next question is, what about transfers to non-relatives? For example, a 30-year-old friend. Those are categorically not allowed. The only transfer that can take place is between you and your children, and in some cases, you and your grandchildren. Also between spouses. Transfers between siblings do not count. No other relatives, no other friends will qualify for this exclusion. And keep in mind, it is not relatives. It is very specific relatives. A lot of folks get a typical scenario that gets folks in trouble is that two siblings inherit property, then one of them decides they don't really want to be involved, so the other one buys them out, and then they get reassessed. And they're saying, why did I get reassessed? This is between our family, and we both inherit from our property. The law only addresses parent to child. Under the previous law, it also addressed child to parent, so a child could leave the property to their parent. It's unclear whether Prop 19 allows that reverse transfer from to child to parent as well as parent to child. Somebody asked me to repeat the number of the bill I mentioned. So it's Senate Bill 539. Senate Bill 539 is authored by State Senator Robert Hertzberg. And this is the bill which is essentially the cleanup language to all the issues with Prop 19. Next question, there's so many ways that Prop 19 was wrong and really must be repealed, not to mention the fact that Prop 19 violated the single subject rule. I'd like to see the assessor's office support ACA 9 to repeal Prop 19. I think I'm vaguely aware of ACA 19, but I actually agree with this. I do believe that we need to go back to the drawing board and look at the intergenerational transfer, the family, the parent to child transfers that were reduced. I don't think people intended that in many ways. Prop 19 is very regressive because the people who are most impacted by it are those who have very limited real estate holdings who hope to transfer it to their family members. And I don't think people truly understood that. Next question, how long does the property have to be your child's primary residence to qualify for the tax savings? Forever. So if your child inherits your property in the tax base, they may keep that tax base as long as they live there. If they decide they want to move out and rent it, at the time that they move out and rent it, we would reassess that property to market value. Obviously, they can still own it. They're just going to have a big increase on their property tax bill. Next question, how can I get a copy of how Prop 19 works, the benefits and the negatives? I urge you to visit my website, which is assessor.lacounty.gov. You can also go to the Board of Equalization website. They also have a lot of information on Proposition 19 that will talk about a lot of these different issues. Next question, but can young veterans who inherit a home while deployed get an exemption for Prop 19? So as it is written, that is one of the questions that we have. So here's an example. You're a veteran and you inherit your mother's property. Then you get deployed for 24 months. And while you're gone, because soldiers don't make a great deal of money, so you may not be able to afford the mortgage on or the cost of that home. So you decide to rent it out while you're on deployment. Under the reading of Prop 19, we would be required to reassess that property to market value because the law says it has to be your primary residence. And while you're on deployment, it's not your primary residence. Obviously, that's absurd. Nobody agrees with that interpretation. That's what it says. That needs to be addressed. That's hopefully going to be cleaned up in the language in Senate Bill 539. Next question is the $1 million value exclusion indexed to inflation. I don't believe it is. Robert, do you know?
We'd have to take a look again. I'm not exactly sure what party is responsible for the inflation, keeping track of the inflation, but I believe that there may be a provision that provides for that to increase over time. I
would hope so. They should have thought about that years ago with the homeowner's exemption as well. It's a $70 savings, which was probably a little bit more meaningful 50 years ago when they put it into effect, and homes were only worth about $25,000. But now that they're worth $800,000, that savings was never indexed and no longer keeps up with inflation. Next question, how can we keep the first half of Prop 19, the benefits for seniors, but overturn the second half, the confusing results for inheriting children? The second half was not made widely known to the public during the campaign and very unfair. I agree with your assessment. The only way that can be changed is through another constitutional amendment that has to go to the ballot. The next window to make that change is November of 2022. I think there are some efforts, including the Assembly constitutional amendment that was mentioned earlier. I think it's ACA 9 that would make an effort to put this back on the ballot to undo that change, something I would support. Next question says, explain a partial reassessment. So let's say that you have two brothers who inherit a home, and one of them decides they don't want to be involved in that home anymore. They sell it to the other brother. Under that case, we would do a partial reassessment, 50%, because 50% of the ownership remains stable, 50% changes. And so we would only do the 50, that's a partial reassessment example. Robert, anything more on that? Is that pretty?
No, that's a perfect example.
Okay. So next question, if a house was considered transferred as of the date of death of the parent in early 2020 prior to the passage of 19, but because of COVID, probate did not initiate until late August, so no executor until then, how would it have been possible to notify of any change since no one was legally assigned to act on the estate's behalf? All right, Robert, I'm going to kick that one to you.
Sure. So there's a couple of things that it appears to be going on here. First is they're asking about the reporting of the date of death to our office via a change in ownership statement. And then also with regard to Prop 19 and whether or not there was any type of exclusion that's available, what law applies. So first of all, a change in ownership statement is supposed to be filed upon the date of death of a real property owner. It's supposed to be done in the case of a trust within 150 days, or in the case of, in any other case where, for example, an estate is probated, it has to be done before the inventory and appraisal of the estate is due to the court. So that form should be filed at some point. Now, with regard to what law applies in this case, because the date of death constitutes the date of change in ownership here, we would go under the old rule, Prop 58, because Prop 19 only becomes effective as of February 16th of 2021. Because the change in ownership event occurred before then, the old rule applies. So they would apply or file a Prop 58 application with our office to request that there be no reassessment as of the date of death.
Thank you, Robert. So there's a follow-up question to one of the, for instances, I gave during my remarks about the requirement that all children move into a property after their parent's death, which is what Prop 19 seems to suggest. I can report on that specific example that the California State Board of Equalization did issue an interpretive ruling that in the case that there's multiple children inheriting their parents' property, if only one child moves into the property, that will be deemed to satisfy the terms of Prop 19. We still need legislation to clarify that that's what the intent is, but in the short term, you don't have to worry about having all of your kids move into your house because we do have an interpretation from the State Board of Equalization that opined that just one needs to move in, but it is one of those elements of the law that need to be clarified as it specifically relates to Prop 19. Next question, if a child lives in property as a primary residence within a year of the death of the parent, and after years, so we've actually answered this question. So if your child moves out of the house that they inherited and decides to rent it out, it will be reassessed to market value, yes. Next question, is this presentation available via email? Yes, it is. We'll send a copy to Krista and she can make that available to you. Next question is the $1 million breakpoint that we've been discussing, the market value. It is market value, is it not, Robert?
Yeah, so the $1 million, it is the $1 million exclusion limitation or allowance for Prop 19 parent-child transfers. It's applied to the fair market value of the property as of the transfer date.
Okay. Next question, is it better to sell my home now and give my daughter the money, or should I wait? That would, I regret, I can't give you advice on that. That would constitute legal advice to a degree, is something they don't want me to do. I urge you to speak to the financial advisor in order to make that decision. Next question, I think this one I may need your help on. Robert says, what is the situation for special needs trust? That's one I'm not as familiar with.
Sure. So sometimes parents with children with disabilities or special needs, they will place property in trust for that child. They can be configured in a number of different ways, revocable, irrevocable. So it will really depend on the specific language of the trust. So you might want to speak with your legal advisor, legal representative as to how your particular trust is configured, and then consult with the appropriate property tax authorities on that.
So some really good questions, really very specific questions. Thank you very much. This next one is also a little bit more technical. The question is there a reassessment when a spouse dies and the trust is converted to a survivor's trust? As a general rule, transfers between spouses are not reassessable. Robert, in the case of this sort of trust conversion, does that still apply?
Again, provided that this is this particular trust is formatted in the way that many family trusts are formatted, yes, it would appear to be an interspousal transfer like you were indicating, which is not a reassessable event.
I should probably say, as an aside, as it relates to trusts, we all know that trusts are a very valuable tool for providing direction on how an estate should be handled upon the death of a property owner. I can tell you that issues and problems with trusts are one of the most significant issues for public service that my office gets. People know that it's a valuable tool for transferring property, but it is a relatively precision step, and any deviations from established rules and regulations will result in a reassessment and and a supplemental tax bill. One of the things people frequently do inadvertently is they add or they delete a name from property ownership from the deed going into the trust or vice versa. The rule of thumb is that the ownership of the property must look identical in the trust going in and coming out. Any deviation will be viewed as a change in ownership and result in a reassessment. Be very, very careful about those. Next question. If a child has been living in a parent's house for years that has Prop 1319, will it stay under Prop 19 if the parents have another house with Prop 19 as their main residence? The only property that qualifies for the property tax benefits under Prop 19 is their primary residence. You cannot have two primary residences. You must declare one by filing a homeowner's exemption. That's the only property that can be considered. Sometimes, well, if you owned a home and a secondary home, and you have two kids and you want to leave one home each, in that scenario, only one child would be able to benefit from the Prop 19 property tax base. The other one would be reassessed to market. What's the difference between Prop 19 and Prop 58? Proposition 58 was the predecessor to the child intergenerational transfer. Under Prop 58, your children could inherit your primary residence of any value without reassessment and $1 million in additional property without reassessment. If you, for whatever reason, your heirs were neglectful in letting the assessor know about the change in ownership, if they failed to file the Prop 58, even if several years had passed by, we would still be able to apply the Prop 58 even prospectively. We didn't have to be able to do it retroactively in all cases, but you had, I believe, a couple of years to take care of that administrative work. Prop 19 does not provide that sort of discretionary wiggle room to apply the new law. You have to do it in 12 months. After 12 months, it is reassessable, and there's really nothing that can be done to change that. Prop 19 only allows the primary residence of the parent to be transferred. After $1 million in market value has been reached, you'll now have a new higher blended assessed value in tax base, and the child has to make that home their primary residence. Next question. If you sell your home now, will you give full value to your child? If they don't repeal Prop 19 and she inherits it on your death and doesn't live in it, it will be reassessed and a large new tax bill will occur. Not sure. I know all Robert, I'm not sure I quite get the gist of that question. Are you?
Yeah, I think this was it was an answer to a question that was posed earlier. That essentially the person asking the question wanted to know what would be more advantageous. I think you had indicated that giving an answer to that would constitute legal advice. So this one we might want to just leave alone for the moment.
Okay. Next question. What about selling the property to intentionally defective grantor trusts? The reassessment. I'm not familiar with that protocol. Robert, are you familiar with that?
Vaguely. So I have come across intentionally defective grantor trusts in the past. They are very specific. They have a more specific purpose than the general family living trust, revocable or irrevocable. There is very good guidance that's provided by the Board of Equalization in their property tax annotations change in ownership section. So if the person asking that question would like to information on that, I'd be happy to send them links to the BOE's material on that.
So I did want to let everybody know that I only had an hour for this this presentation. I want to keep the presentation going, but I'm going to have to make this my last question that I answer, and then Robert and my other staff will stay on the line and continue to answer questions, and they're all very knowledgeable and capable. Will help you get the answers that you need. But the last question I wanted to take is from Merritt McGinley, who is a former colleague of mine. We both used to be staffers to Los Angeles Councilwoman Ruth Galanter back in the 90s. And she said, she says hello. And actually, it's not a question. She just said she and her mother appreciate the information we got today. And I wanted to thank Merritt. It's great to see your name and hear from you. It's been a long time. But Krista, thank you for the opportunity to speak with everybody. There's a million questions here. I want to get answers to as many as your time will allow. I apologize I can't be here for the remaining part of the program, but I'm willing to come back as often as you need me to answer these and other questions that folks may have about property ownership in LA County.
Well, thank you. And on behalf of Episcopal Communities and Services, we appreciate your time today, Jeff, and we will stay on for those who want to stay and go through the questions and answers. So thank you for your time.
My pleasure. Thank you so much. Thank you, everybody. Stay safe.
Okay, so Aldo, Robert, do you want to take it from here?
Sure, I'm happy to continue going through the questions in the chat if you'd like. Let's take a look here. What happens if I have a home which I live in and also a condo which I rent to my children or my daughter? I have 2 children. So the home that you live in that you use as your principal residence, that will, when you pass away and transfer it to one or both of your children, be eligible for Prop 19 exclusion. The condo, which is not your principal residence, will not under Prop 19. Next question. If I don't make my parents' house my principal residence, the new tax rate is applied to the entire market value or the excess over $1 million. So if you choose not to move into your parents' principal residence or former principal residence, the transfer of the property will no longer be eligible for a Prop 19 parent-child transfer exclusion. As the assessor pointed out, one of the requirements is that the person who inherits the property begin to occupy that property as their principal residence. So it would be here, the property would be reassessed to market value. The $1 million exclusion would not apply.
The next question is, Prop 58 was the 1986 law that extended the protections of Prop 13 to property transfers between parents and children. I think that was just a statement, a response. Let's see, the next question would be a deed preliminary change in ownership report and claim for reassessment exclusion for the transfer between parent and child were notarized and mailed to LA County prior to February 16th, 2021. LA County Recorder's Office recorded the deed in April. When and or how will the parties receive the notification of reassessment exclusion determination?
So the ownership division of the assessor's office, they review all sorts of proposition claims, including Bayshore Valley transfers, as well as parent-child and grandparent-grandchild transfers. So when they've completed their investigation, they will send out a hard copy letter indicating whether or not your claim has been approved. One thing I would mention is that before the February 16th changeover from Prop 58 to Prop 19 occurred, there was kind of a mad rush to have deed transfers from parents to children recorded. Due to COVID and the backlog and the number of deeds that were being recorded, many that were executed prior to February 16th, they were not recorded until afterward. But the Board of Equalization has given guidance that allows the assessor to view these transfers that were executed before February 16th as Prop 19 or Prop 58 eligible, notwithstanding the fact that they were later recorded afterwards. So just a point of clarification.
Thanks, Robert. Next question is, if I inherit my parents' house and the benefit of moving and keeping the tax rate has never been used, how many times can I sell and move?
Okay, let's see. Okay, so I think what this question refers to is an individual inherits their parents' property and they want to transfer that tax base to a new principal residence, move and transfer their tax base. So under Prop 19, provided we're working with the senior citizen benefit, you would be able to take advantage of that up to 3 times. You can move and transfer your tax base to any to a property located in any county in California. The property does not have to be of equal, the replacement property does not have to be of equal or lesser value. However, if the replacement property is of greater fair market value than the property being replaced, there will be an adjustment to the tax base that's transferred over.
Next question is from Elizabeth Sachs. Is there any way that we can put an end to this proposition, and what steps would we need to take?
Sure. So as the assessor indicated, Prop 19 was a constitutional amendment. It's our understanding that it would require another constitutional amendment to change it or get rid of it. So at this point, it would require another ballot measure. And it sounds like there are parties that are already looking into that, but at the moment we're focusing on implementing Prop 19 as it currently stands.
The next question is, I understand the homeowner's exemption went up this year from 75,000 to 300,000. As a senior, how do I apply for that?
So the homeowner's exemption is a $7,000 credit. That basically what it means is what your assessed value is. If you have the homeowner's exemption, it's reduced by $7,000. And so that translates roughly to about $70 in property tax savings each year. It's automatic once it's been applied for, but it's my understanding that that $7,000 figure hasn't been adjusted since the exclusion or exemption was created in the 70s. So there is some frustration that it really isn't that much money. But at this point, it still appears to be a $7,000 exemption, and I don't believe it's changed.
The next question is from Linda, who says, I've heard about a scam whereby the scammer claims a property as theirs and changes a property into their own name at the registered recorder's office. The legal homeowner receives a notice to vacate, and the scammer is now the new legal homeowner. Is that true?
There are a number of different scams, fraudulent activity that occurs with regard to real estate. I believe that the assessor in his presentation gave some information on the real estate fraud task force. If you have a specific question or there's a situation that you need to have addressed, we would recommend that you contact our partners at the task force and let them know what's going on and see what would be the best course of action in your particular circumstance.
Thank you, Robert. We'll provide the presentation at to the organizers, to Krista and Jennifer, and you'll find the phone number right there. The next question is from.
Yeah, I'm sorry, Aldo, really quick. What we'll also do is this will be recorded and posted on our website under past events. And we will also send a copy of the recording out to everybody that registered.
Thank you. The next question is from Ron, and it says, parents' property held in the name of their trust with the children listed as their heirs. Is it better to sell in the name of the trust or transfer title to the children and then sell?
So again, this kind of comes down to a legal question. What should I do? What should I not do? We're not allowed to answer those at the assessor's office because we're not in a position to give you legal advice. So if you think that there's going to be a particular advantage one way or another, you'll want to seek advice from either a real estate attorney, a property tax attorney, CPA, some professional who would be able to give you advice that you can rely upon. Fortunately, we're not able to do that, but there are potential reassessment consequences to doing it one way or another. So that would be another thing that once you've decided what you're going to do, you would want to ask them about that as well.
The next question is from Tammy Call, and it says, how does a blended rate apply to a property valued at $2 million?
Let's see here. Okay, so I believe what this question is asking is there is a property that is being transferred from parents to children. So they're requesting that the $1 million principal residence exclusion be applied. What will happen in this case is $1 million of that $2 million fair market value will be excluded. The prior tax base will be be transferred onto the children, but the remaining $1 million that was not excluded under Prop 19 will be tacked onto that tax base, and the 1 million plus the tax base will be the new tax base moving forward for the child or the person who received the property.
The next question says, if a child has been living in a parent's house for years and that has a Prop 13 value, will that stay under Prop 19 even if the parents have another house with Prop 19 as their main residence?
So I think the assessor may have gone over this one already. Essentially, there is only one, in this case, if we're talking about parents and children, a parent can only have one principal residence. It's essentially where they live and plan to return every day. So if there's additional property, say for example, a second home, vacation home that they're looking to pass down, they're welcome to transfer that to their children when they pass. It's just that property won't be subject to or eligible for a Prop 19 exclusion. Only the home that they live in when they pass away.
Thanks, Robert. The next question is from Gary Eden, and it says, we currently live in my father-in-law's. When he passes, my husband inherits through a revocable trust. When we pass the property onto our children at some point, is the property reassessed at market value?
So when your father-in-law passes away and the property transfers, I'm assuming under this example, to his son, that transfer would be Prop 19 eligible, provided that you continue to live in that you and your husband come to move into the property, file the homeowner's exemption claim. If you decide to use that as your principal residence moving forward and continue to do so until you pass away and want to pass that on to your children, your child, provided Prop 19 is still in effect at that time, would again be able to inherit the property and the tax base, provided they meet all the requirements under Prop 19. That means that they would also have to move into the property and claim the homeowner's exemption within 1 year of inheriting the property. So it just depends on who's going to live in the property, if they're going to live in the property, and if they qualify under Prop 19.
The next question, I believe, would be more guided towards CPA, and it says, can your heirs' children have your property at a step up of cost base to avoid capital gain taxes?
Right. So that's a question that's a little bit outside of the property tax realm. So that question, as Aldo pointed out, would be better directed to a CPA.
The next question is from Michelle. It says, I am a senior. If I sell my home and wait in a rental for a few years more to move into a new owned home, will I still be able to transfer my tax base? How long do I have to be able to transfer that tax base?
Sure. So under the senior citizen benefit under Prop 19, you have 2 years between the sale of your original home and the purchase of your replacement home to qualify for the base year value transfer. So say you sell your you sell your home, you decide to move into an apartment for a year, and then purchase a new home, and you are going to use that as your principal residence. Because it's been done within that 2 year period, you would be eligible to transfer your tax base over. One thing I would also add too, though, is if you purchase a replacement home and you plan on adding on a pool or a second story, some kind of new construction of the property, if you want that to fall under the Prop 19 base year value transfer benefit, the new construction will have to have been completed within that 2 year period as well. So that's something to consider when looking at how much time you have.
Thanks, Robert. The next question is from Kurt, and it says, my mother passed away this May after being bedridden for a year at home. Both my brother and I have lived there for 4 years caring for her prior to hospice care. The house was appraised at 1.2 million. Will we inherit a portion of her tax rate? She was not able to transfer the home to us prior to her passing due to her condition.
Okay, so in this situation, there's an additional piece of information that would be required for us to let you know what the inherited tax base is. So what we would need to know is what the tax base she was paying on. Say in this situation, your mother was paying on her tax base before she passed away was $500,000. If you applied for Prop 19 and it was granted, you would inherit that $500,000 tax base moving forward. If let's see, yeah, so really that's the key piece of information. It doesn't matter whether or not she was able to pass it on to you when she was living, or if your inheritance, or if it was passed to you upon inheritance. Prop 19 functions in just the same manner. In this case, you would file your Prop 19 claim form based on the date of death transfer, and you would want to make sure, because Prop 19 is active, you would, if you both plan on, if one or both of you continue to live in the home or intend to continue to live in the home, you'll want to file that homeowner's exemption claim within 1 year of that May transfer. That's going to be really important, as the assessor pointed out.
And there's a second portion to this question. Pretty much in addition, we have a third generation beach house in San Diego that is a rental property that is valued at 2.9 million. I'm assuming that the tax rate will just like crazy at this to a point that we will not be able to afford it.
Sure. So if this beach house was also a property of your mother's, it was essentially a vacation home, not used as her principal residence. As of her date of death, there is no exclusion available. So it will be reassessed at current fair market value as of the date of death. So if $2.9 million was the fair market value at that point, that would be the new tax base. If it was something above and beyond that, that would be the new tax base.
Thanks, Robert. The next question is from Trina Duke, and it says, can a person move back into a home to reestablish primary residency? If yes, how long to establish the residency?
You can move back into a home that you previously used as your primary residence. Say you have one home and you have a vacation home. You retire, so you decide to move from your original home into the vacation home and start using that as your principal residence. You can then later move back into your original home and have that reestablished as your principal residence. The main way that the assessor's office determines what is your principal residence is by which property you claim the homeowner's exemption claim with. So if you do decide to move in that manner, you'll want to make sure that you're constantly updating the assessor's office as to which property is your principal residence by refiling and canceling the appropriate homeowner's exemptions claims. So that's probably the easiest way for us to keep track of that.
Next question reads, what percent of today's annual residential sales qualify for Prop 13?
So Prop 13 is still in effect. Prop 58 and 193 were something that were somewhat separate from Prop 13. But essentially what Prop 13 says is your property value will only go, your assessed value of your property will only go up a maximum of 2% each year, provided one of two events does not occur. One is if there's a change in ownership of the property. So for example, when property is sold, we reassess it. Also, when there's new construction of the property. So as I said before, if you had a pool or a second story, there's some kind of new construction to the property that adds square footage or some other utility to the property, we'll reassess that new construction. But whenever, but aside from those two things, Prop 13 is, the protections under Prop 13 are going to apply. Now, as far as sales, property is pretty much when there's a sale, the property is going to be reassessed, because generally a sale is indicative of a change in ownership, which is a reassessable event under Prop 13. So I would say, just on my basic understanding of this question, the percentage of today's annual residential sales that qualify for Prop 13, it would be 100%, because Prop 13 applies to all property.
The next question is, if my property sells for 1.2 million and the price of the new home is equally priced, does that mean that I'm able to transfer my property tax for only 1 million and there will be a partial reassessment for the remaining 200,000?
So if you're taking advantage of the Prop 19 base year value transfer benefit, if the market value, if basically the price that you sell your original property for and the price that you purchase your new residence for is the same, you'll be able to transfer your base year value, your tax base of your original property over to your replacement property without any adjustment. The adjustment comes into play when the new property is more expensive than the sale price of the original property. So here, whatever the tax base of the original property was, you'd be able to move it over without any type of upward adjustment.
The next question is, my home is worth 1.5 million. If I move into a retirement home, can I give it to my daughter and keep the same tax base? And I believe this is what the assessor had previously covered. It's still a little bit unclear.
Yeah, let's take a look. The question is a little bit unclear. It's hard to tell whether or not exactly the parent is intending to transfer their base year value over to their new home, or they're intending for their child to inherit their tax base. One thing I can say though is you cannot have both. You cannot have both benefits. So if a parent is intending to transfer their tax base from their original property to their replacement property, their child, even if they purchase the parent's original home and they intend to take advantage of a parent-child exclusion, there has to be a reassessment at some point. So I guess basically you can't the parent can't take advantage of the base year value transfer, and the child can't take advantage of the parent-child transfer exclusion at the same time.
And then, Robert, just real quick, if in this situation, if the resident moves into one of our communities, it's not a real estate transaction, so the base would not transfer over to our communities, and so they would be able to transfer the Prop 19 to the daughter, because the retirement home is, again, not a real estate transaction. So that wouldn't count as a primary residence in this situation.
Correct. As you had pointed out, since they're not purchasing their replacement residence in the case of your facilities, it wouldn't meet one of the qualifications or one of the requirements for a Prop 19 base year value transfer. So the child would be able to take advantage of the Prop 19 parent-child exclusion transfer in this particular situation where the parent moves into one of your residences.
Robert, and then the next question is, what if only one husband is 55 or older, but the wife is not 55 yet? Does this still apply?
Sure. So if only one of the spouses qualifies for Prop 19 base year value transfer benefit, that's fine. The base year value transfer can be approved. It doesn't matter that the other spouse is under the age of 55. Only one of the spouses has to qualify.
Do stepchildren count under Prop 19?
I believe they do. Again, that's one of the things that isn't particularly clear under the Prop 19 ballot measure language. But if we are expecting the parent-child qualifications to be the same as they were under Prop 58, a stepchild would qualify for the exclusion.
Next question is from Marjorie, and it says, if I move while I'm alive and purchase a new home near my child, then I die and they move into my home within a year, would they get my new tax base?
Yeah, so in that case, if the child moves into the home that you purchased near them and the home that you used as your principal residence at the time you were passing, it would appear that would they be eligible for a Prop 19 parent-child exclusion.
The next question is from Susan Briggs, and says, we have more than one home. Can we transfer a home to a child now while alive without triggering a new assessment?
So if you own more than, so I would say more than one property. Just to keep things simple, you have one home that you're living in. You may have other houses or property, but say, for example, you sold the home or you transferred the home that you're living in to your child or one of your children, and then you move into one of the other houses that you own and use that as your principal residence. When you pass away, say you decide that the home that you lived in and passed away in, you want to transfer that to another child. That would be eligible for the Prop 19 parent-child exclusion again. So you can transfer as many principal residences as you want to your children, But again, you can only have one principal residence at a time.
Thanks, Robert. The next question is about special needs. How does this proposition affect special needs trust? My parents have 2 homes and one of them is in special needs trust for my sister. Will that house be reassessed?
So again, it depends on how the trust is set up. If it's set up as a revocable trust, a revocable living trust, where your parents have the ability to revoke the trust during their life, but when they pass away, the property transfers, beneficial interest in the property transfers to your sister. At that point, that may be Prop 19 eligible. Provided that the real property that's in the trust is their principal residence. So again, trusts can be set up in many different ways. You'll want to find out if it's a revocable trust or an irrevocable trust, first of all. And if it's an irrevocable trust, who has the benefit of the property while the parents, who I presume are the trustees, are alive. So those are some questions that they'll want to speak to their estate planning attorney about.
Thanks, Robert. The next question is about the webinar being available again. Yeah, as it was mentioned, it was going to be available in the organization's websites. Are stepchildren considered eligible children? I believe we covered that. The next question is, would a probate, estate trust lawyer, and or realtor be aware of the need to apply for the reassessment exemption for a parent-to-child transfer? Just wondering how one would have learned to do this. Things.
Yeah, sure. So many estate planning attorneys are aware of it. However, I have met many who are not aware of it. So in planning, if you're in a position where you're planning your estate, you're going through the trust or will creation process, that may be something that you want to consult with your estate planner about. Is that something that they're aware of? Is it a service that they offer when you pass away and your heirs or beneficiaries are looking into how to administer your estate, whether or not they would be someone that could be turned to. So you would just have to ask the questions yourself of your particular estate planning attorney.
Thanks, Robert. The next question from Patty says, can the child take the $1 million to another house in the States?
So in this case, I'm assuming that the situation is the parent passes away and or transfers their property to their child, and the child wants to know what can be done with that $1 million exclusion limit. So really, that $1 million exclusion limit is applicable only for the purpose of excluding a portion of the assessed value of the transferred property from reassessment. So that $1 million can't be transferred around between different properties. It's just to be applied towards the reassessment of the principal residence transferred from the parent to the child.
Thanks, Robert. The next question is, I'm over 55. Can I buy a new home prior to selling my home and still transfer the tax base? I believe that's yes, correct?
Yeah, so the purchase of the original or of the replacement property and sale of the original property, those can occur in either order. As I pointed out earlier, it appears to be the Board of Equalization's opinion that the over 55 requirement really applies to the sale of the original property. We're still waiting on some clarification as to whether you have to be 55 at the time of the purchase of the new property, though.
Next question coming from Nada says, if our primary residence is in a revocable trust and one spouse dies, will there be a reassessment at that point?
Again, you'll have to take a look at the particulars of your trust, but generally the way that these family trusts are set up are both the spouses are beneficiaries and trustors of the trust while they're alive. When the first one passes away, their interest transfers to the surviving spouse. As the assessor pointed out earlier, that will constitute an interspousal transfer, which is excluded from reassessment. So the property wouldn't be reassessed in that particular case generally.
Thanks, Robert. The next question, what can we do to repeal Prop 19? I believe we covered that already. Can your office mail a brochure that fully describes all the details of Prop 19? That brochure is found on our website. It's assessor.lacounty.gov/Prop 19. You can find other helpful forms there as well. Next question. will be going back to the example of the brother who sold his interest to his other brother. What happens if the brother who disclaims his ownership interest? Will there still be a partial reassessment?
So disclaimers are a little bit particular. Generally, instead of disclaimers, what I would say we see more often is something called a non-pro rata distribution of a trust estate. So say, for example, there's a house in a parent's estate, a trust, and there's a bunch of cash. If, say, for example, the home is valued at $500,000 at the time of death, and there's $500,000 in cash, one brother they want the property to transfer to one brother, they can allocate all the cash to one brother and the entirety of the property to the other. And then upon distribution of the property to the one brother, there would not be a partial reassessment. He would be able to inherit the property outright without any reassessment, provided Prop 19 excluded the entire parent-child transfer from exclusion.
Thanks, Robert. At this point, I want to do a time check. Do you have any more time, Robert? Because it's going to be 3:30.
Yeah, I'm happy to stick around as long as is needed. I know that this webinar probably has some time restrictions, but we can check in a little while if that's the case.
Okay, cool. So then there is the next question, I believe. It says there were many attorneys advertising the creation of irrevocable trust to go into effect prior to the February 16 deadline to preserve the assessed value of the property for children. These trusts were very costly and there was a mad rush to do them. Will these Prop 19 trusts work?
So it kind of depends on what exactly the trust said. So if the intent was to transfer them in, if the trusts were irrevocable and the children were the beneficiaries of the trust, and the transfers to the trust occurred before February 16th, they would qualify for a Prop 58 exclusion. However, again, depending on how any particular trust was formatted, it would essentially be the same as transferring outright from the parent to the children before February 16th. So I'm not familiar with the specifics on these particular trusts, or if there was a class of them that were all worded similarly, but that would be generally what I would have to say about that.
Thanks, Robert. We have a question from Kirk saying, we placed our mother in an end-of-life home when she was close to passing because she didn't want to pass in her residence. She was there for only 12 days and passed away. Does these 12 days constitute a move? If the answer is yes, then how would a long hospital stay prior to passing be interpreted?
Sure, and so this is the problem with the current with what we currently have on Prop 19 that the assessor was talking about. Whether or not those 12 days she regarded the hospital as her principal residence, or if it was just a place that she was staying and she regarded her home as her principal residence still, we don't have guidance to let us know how exactly that should be interpreted. So we're waiting on some information from the state legislature, potentially from the State Board of Equalization, to give us a better idea of how we would deal with these particular situations, because they are tricky, but without particular guidance, we're not in a position to make an interpretation on how the law would be applied in this particular situation.
Thank you. The next question is, how do we prove which property is our primary residence? And I believe that would be by filing the homeowner's exemption.
Right. So generally, the homeowner's exemption is how the assessor's office on its face determines which property is viewed as a property owner's principal residence. There are cases, many cases, in which property owners don't claim the homeowner's exemption for the place that they're living, even though they could do so, and then later on apply for some kind of benefit that requires the property to be recognized as their principal residence. In that case, if there is no homeowner's exemption, we also accept extrinsic evidence, other types of information like um, information indicating that like your driver's license or where your utility bills are being paid. Information like that helps us determine where you regard as your principal residence and where you're living, even if there's no homeowner's exemption claim on file. But as Aldo pointed out, the easier way is just to file a homeowner's exemption claim.
We have the next question come from Julian. Says, if we own only a minority interest in the property, can our heirs inherit it without reassessment?
Again, there has been some guidance on how partial interest transfers are going to be dealt with under Prop 19, but yes, in general, the inheritance of a partial interest in property by a child or parent in a parent-child transfer situation would be eligible for the Prop 19 exclusion.
Thanks. The next question is, must the heirs occupation of the primary residence begin precisely 12 months of date of death, but no sooner?
So what I would say is that the heirs' occupation of the property and also their filing of the homeowner's exemption claim, that can happen no later than 12 months after a date of death transfer. So the earlier that you're able to file that claim form and move into the property within after following the parent-child transfer, the better, because you don't want to be approaching that 12-month mark and then being in doubt as to whether or not you're missing the deadline. So 12 months is the absolute latest that you would want to do those two things.
The next question is from Dorothy, and she says, my husband died in April 2020. Our home is in a revocable trust. I still live in our home. Is there anything I need to report? I am 85. Home is now 1.5 million.
So as I pointed out, generally in these types of family trusts where husband and wife hold their property in a trust, when the first spouse to pass away dies, their interest in whatever real estate is held under the trust automatically transfers to the surviving spouse, which is still held under the trust. There's nothing really that you need to report to our office in that case. You can file what's called a change in ownership statement, death of real property owner. It'll let us know that one of the spouses has passed away. It won't necessarily trigger a reassessment though because of that interspousal component. But that may be something you want to file or fill out and submit to our office just so we know which of the property owners are still living.
Thank you, Robert. And I believe the next question from Char was similar to that, so I believe that covers it in this. The next question is from JP, and it says, I co-own a property with my parents as joint tenants. My father passed away earlier this year. Do we need to file the passing of my father, and what are the assessment consequences?
Sure. So joint tenancies are a little bit tricky. It depends on how they were formed. For example, did you and your parents acquire the property as joint tenants based on a sale or something like that? Or did your parents acquire the property and then add you on as a joint tenant? So depending on how that particular joint tenancy came into effect, that may determine the reassessment consequences. One thing that you'll want to do, though, for sure, is what I was mentioning earlier, the change in ownership statement, death of real property owner. You'll want to fill that out and submit it to our office, the assessor's office. And what that'll do is it'll inform us that your father has passed away. And because of the way that joint tenancies are, his interest, assuming it's a 1/3 interest, it will automatically, upon his death, have transferred in part to you and in part to your mother. So now you and your mother would each own 50% interest in the property. Depending the interest that was transferred to your mother, it's likely excludable as an interspousal transfer, but you may also have to file a parent-child transfer exclusion claim form based on the interest that transferred from your father to you. And so, let me see here. It doesn't say in your question whether or not your father passed away before or after the Prop 19 effective date. But if it was before February 16th, you would file a Prop 58 claim form. If it was afterward, you'd file a Prop 19 parent-child transfer exclusion claim form. All these forms are in the form section of our website. They're easily accessible, and you can print them out and either mail them or email them in. There's a email address at the top of each of these forms.
Yeah, Robert, he replied that they bought the property together and the passing was January 2021.
Got it. So it would be a Prop 58 claim form. And in this case, it looks like what I had discussed, your father's interest would have passed 50-50 between you and your mother. So you'll want to file that Prop 58 claim form.
Thanks, Robert. The next question is from Bill, and it says, I own my home. When my mom passes away, my brother and I shall inherit the home. Please advise, must I sell the home and reside in mom's home for Prop 19 exclusion?
Yeah, sure. So if you wanted to have the transfer of your mother's home excluded from reassessment, either you or your brother would have to move into the home and claim it as your principal residence by filing a homeowner's exemption. So it doesn't matter which of you, even if both of you inherit it, but one of you will have to move in and claim it as your principal residence.
Thank you. The next question is from Jay. If the property tax basis was transferred once and is now being transferred again, is the sales price of the house being sold the first time or the second time used to determine if there is an increase in the property tax basis?
Yeah, sure. So if you've already transferred your base year value once and you're doing it again, we'll call the home that you're living in now your original property, even though you've done this already before, and the home that you're expecting to purchase as your replacement property. We would use the sales price and purchase prices of those two properties, the second and third property, to determine whether or not your tax base needs to be upwardly adjusted in any manner. So the initial sale price of the first original property you had doesn't figure into this new calculation.
Thank you, Robert. The next question is from Shar, and it says, if someone can't remember if they filed their homeowner's exemption, is there a way to check? There is a way to check that I know of. That's if you go to our assessor portal, that is portal, assessor.portal, or is it the reverse?
Yeah, if you Google assessor portal, it'll be the first thing that comes up. All you have to do is enter either your street address or your assessor identification number. It'll come up with the web page for your specific property. And there's a section at the very top. It says exemptions. Right next to it, if you have the homeowner's exemption applied to your property, it'll say homeowners. So that's the easiest way to check.
Thank you, Robert. The next question is from Trina, and it says, please clarify the previous answer. A move to assisted living does or does not qualify as a change in principal residence?
So on its face, it would qualify as a change in principal residence. But as Krista was pointing out, in the particular circumstances here with these living facilities, because the senior citizen who is going to move into one of these facilities is not purchasing an interest in real property, it would not qualify as a purchase of a replacement property for Prop 19 purposes. So it would qualify for a transfer of a principal residence. It would not qualify as the purchase of a principal residence. So it's a kind of a fine distinction, but one that probably should be made.
Thanks, Robert. And the next question is, if I transfer property to a child, oh, no, wait up. I think I must have skipped. Oh, no. If I transfer property to a child while I'm alive, would that be considered a gift?
Yeah, so unless you sold your property to your child, it would be on its face considered a gift. One thing, it's not property tax related per se, but I know that there are gift tax consequences for transfers of real estate between parents and children that are made during the parent's life. So if that's something you're contemplating, you probably want to talk to your CPA about what consequences that may have for you.
And what expert is best to get advice from in regards to financial planning of all these topics? A CPA or an attorney? What specialties do I search for?
Again, it would depend on the specific questions that you're asking about. When it comes to taxes, I would assume that the CPA would be the best resource for you. When it comes to things like creating a trust or transferring property to or from a trust, I would think that an estate planning attorney would be very helpful in that regard. But again, when it comes to property tax consequences, there are specific property tax agents and property tax attorneys. Some CPAs may have some expertise in this as well, that would be able to advise you on what the property tax consequences of any given particular course of action may be. But again, you'll really kind of have to do your homework and be the person asking them the questions. Oftentimes, it may be difficult to determine whether or not they have the expertise that you're looking for without asking. They may not volunteer that information, not knowing that you're looking for it. So the more questions you ask, probably the better.
The next question comes from Elizabeth Saxon. It says, if parents have two properties and want to give one to each child, one child would have a huge assessment and the other one would not if the home is 1 million. Is that correct?
Yes, that would be correct. So the one property that was treated as the parent's principal residence, provided that one child decides to move into the principal residence after the parents pass away, it would be eligible for Prop 19 treatment. However, the other property, as the assessor pointed out, under Prop 19, a property other than the principal residence is going to be reassessed at market value.
Thank you. The next question comes from Judy. And it says, where can we access the BOE current language for the interpretation of Prop 19? Is it on their website?
Yes. So if you just Google BOE Prop 19, it should be the first thing that comes up. Their website is configured very similarly to the assessor's website. There's a lot of resources that they've put out specifically from their staff. They have comparison tables between Prop 58, 193, Prop 6090, all of those, and the changes under Prop 19, as well as some frequently asked questions. So if you just Google Prop 19 BOE or BOE Prop 19, you can access all the resources there.
Thank you. And this question is from Greg, and it says, did you say that one child can buy out the other child when they both inherit the primary residence, and it would not be a 50% reassessment if the one child continues to live in the house as their primary residence? In other words, can the $1 million exclusion be enforced in full, even though there is a buyout of the second child, as long as the first child uses the residence as their primary residence?
Yes, so as we discussed before, only one of the children who inherits the property has to reside in the property as their principal residence. I think what Greg may be talking about is something that I discussed earlier, and that's that non-pro-rata distribution. So in that particular case, neither child, there were two brothers in that example, neither brother is buying out the interest of the other. The estate already had sufficient assets to allocate $500 in real estate to one brother and $500 in cash to the other. But say, for example, there is only the $500,000 property in the mother's estate, and that's the only asset that's being passed down to the children. If one of the brothers wants to buy out the other brother and pays out of his own pocket $250,000 for the remaining interest so that he can hold it 100% himself, there would be a 50% change in ownership upon the transfer of the property out of the trust to the one brother. I guess this would involve a little bit more research on your part and determining what situation applies to you. But the key situations that we're talking about here that need to be differentiated between is non-pro-rata distributions and one sibling purchasing out the interest of another. One is viewed as a strict parent-child transfer. The other is viewed as a sibling-to-sibling transfer. So again, I would turn your attention to the BOE's or Board of Equalization's property tax annotations. They have a section generally on change in ownership, but also one for parent-child transfers. They have lot of really good guidance that address both of those topics in there. So I would highly recommend taking a look at that. And if you don't find the answer there, you're always welcome to reach out to our office with your specifics, with the specifics of your situation, and we can let you know kind of what we think about what's going on.
Thank you, Robert. The next question is from Ollie, and it says, if a trust was written before February of this year, then is it possible to get Prop 58, even if the parents don't pass for years, or do we need to take the written trust to get a property transferred now and just ask for Prop 58?
So really, when the trust is written isn't of particular importance. Of course, if the trust is written and executed after February 16th, no parent-child transfer involving the trust is going to be eligible for Prop 58. If, for example, though, I'll go through a couple different hypotheticals. The trust was written before February 16th, 2021, and the property was transferred into this trust before February 16th, 2021. If the trust is the parent's trust still, there's no change in ownership reassessment regardless. It's not even a parent-child transfer. If the beneficiaries of the trust are the children, and the transfer occurred before February 16th, it would be Prop 58 eligible, and they could file their claim for exclusion even now because the transfer occurred before February 16th. So we would maybe with this example want to clarify what's going on a little bit more, but generally if the transfer occurred before February 16th, it's still eligible even now for Prop 58 treatment.
Thank you. The next question is from JP. Since I co-own a property with my parents as joint tenants, how would or would not Prop 19 benefit me after my parents pass away?
Yeah, sure. So again, this kind of, as I said before with the other joint tenancy situation, it would depend on how the joint tenancy was formed. But here, what would generally happen is one parent would pass away. Their interest would be split up 50-50 between the surviving parent and you. You would claim a Prop 19 exclusion for the interest from the deceased parent to you. And then when the second parent passed away, you would apply for a Prop 19 exclusion for the transfer of the 50% interest from the second parent to you. So you would be applying for Prop 19 twice. It would depend on the value of the property at that time. It would depend on the fair market value of the property at the time of both those transfers. So there's a lot of variables, but that would be the general layout of what you would expect to do over the course of the ownership of that property.
Thank you, Robert. And then we have this question from Sherry, and it says, our parents' home was purchased in the mid-1970s and is protected under Prop 13. The title is held by a revocable living trust. If the home has increased in value to almost $2 million since the purchase, that is the old tax base. Is the old tax base maintained up to $1 million, and the $1 million in additional is reassessed at the new tax base, or is everything over the original 200,000 purchase price reassessed at the new tax base?
Okay, so we're getting into a little bit of a complicated example here, but what I would say is this. I'll give a more general example, trying to use some of the figures that we have here. Say at the time of the transfer from parents to children, the tax base that the parents are paying their property taxes on is $500,000. At the time of the transfer from parents to children, the home is worth $2.7 million. So the question is, what is going to be the tax base that the children are going to pay on if Prop 19 is applied to this principal residence? So the way that you figure this out is you take the greater of two values. One, the existing tax base that the parents were paying their property taxes on, or on the other hand, the fair market value, in this case, $2.7 million, minus the $1 million Prop 19 allowance. So that's 1.7 million. So here, because the greater of those two values is 1.7 million, that's what the children would pay on moving forward, and then would be subject to Prop 13 2% each increases each year afterwards. So that's how that works. I would highly recommend that you take a look at the assessor's website and take advantage of the calculator that's up on the website for parent-child transfer exclusion. Even if you're not intending on transferring the property anytime soon, it may just give you a better idea of how the calculation works. And once you hit calculate, it will provide a step-by-step calculation as to, or step-by-step example of how you arrive at the new tax base for the transferee. So that's probably the best advice that I can give without getting into too confusing an example.
Thanks, Robert. And then the next one's from Diana. It's just, Robert, can we please have your contact information, email and phone number?
Absolutely. So I have included my email in the chat, but I will include that again right now.
We have a question from, I believe this is the last one. Where can I obtain the form for property tax basis transfer? Or is it necessary to call the assessor's office to obtain the form?
Sure. And so all of these forms that we've talked about today, homeowners exemption, Prop 19 base year value transfers for seniors, property owners with disabilities, victims of natural disasters, parent-child, grandparent-grandchild, all of these forms are located on the assessor's website. There is, if you go over to the homeowners exemption at the bottom of the page, or that drop-down menu, there's a section that says forms. There's a search menu on that forms page. You can take a look there and search for the form that you're looking for. It's easy as searching parent, child, homeowners, and that should get you the form that you need. So all of the forms that you would need are available online.
Thank you. And this is the last one. How can we get a recording of this webinar? I believe it'll be an ECS website. So sure, definitely folks can get a copy of the webinar. I believe that wraps up our questions. So I'll turn it over to Krista for a few last words.
Okay, thank you, Robert and Aldo. We really appreciate all the time and great questions. We still have almost 100 people left on the webinar. So you see Robert just put his information in the chat if you want to take note of that. We'll also send it to everybody along with a fact sheet from the assessor's office with the recording. So you will get an email with the recording, a fact sheet, contact information for Robert and Aldo. And then we also will have our contact information for if you're interested in coming to see MonteCedro, Canterbury, Covington, 12 Oaks. We'll put that information as well for you. And then if for whatever reason you don't get the email or you don't see it, please visit our website at ECS4, that's FOR seniors.org, and go to past events. And this will also be there within about 24 hours. Give us 24 hours to do that and we'll get that to you. So appreciate everybody today and those who hung in there with us for the 2-hour time frame. It was a great information. We appreciate it. And you can reach out if you have additional questions and we can track down the answers for you. So thank you, everyone. Have a great rest of your afternoon and evening. Appreciate it.
Thank you.
Thank you.
Bye.